folks. A little housekeeping. We have lunch being served on the mezzanine level. We got the regulatory committee panel coming on, but you're more than welcome to grab some lunch, come in here and eat lunch while you listen to the regulatory panel. I'm going to introduce the moderator, and it's Luke Condor. Associate Director of Centralized Engineering, NRC NEPA, is it pronounced NEPA? NEPA, Compliance Officer with Verizon Wireless. Lucas has worked with Verizon for the past 5 years, where he held such positions as AD Regulatory Central Engineering and Senior Management of Real Estate and Regulatory. Prior to that, he worked for AT&T for 10 years, serving as a senior construction manager and senior account manager. He's been involved in numerous special projects, including working on the launch of 4G small cells, 5G small cells, macro, and DAS deployments. I'm going to let Luke introduce the panel members, so have at it.
Check. Yep, you can hear me? Okay. Hey, thanks for the introduction. I'm up here today with Ben Salter, Erica Diak, Aniela Travers, and Wu Smith, and we're going to be talking a little bit about who you're going to call. Wu is going to give an overview of NEPA rules and Section 106. Aniela is going to talk a little bit more about Section 106 best practices and special use cases. Erica is going to talk a little bit about tribes and tribal updates. And then Ben is going to close us out with a conversation about the waters of the U.S. and in threatened and endangered species. So with that said, who has the clicker? And so if you have questions, feel free to come up and sit in the front row and raise your hand. And I invite this to be a conversation. And one thing that I've learned is I'm usually never the smartest person in the room, but what helps me is knowing who to call when I need someone smarter that knows all the regulatory and environmental rules. So Wu, if you want to kick it off, we'll talk a little bit about NEPA.
Awesome. Well, thank you guys for joining us for lunch today. So what is NEPA? This is a question we get a lot. So let's just kind of start with the basics. The National Environmental Policy Act was enacted in 1969 under Nixon, and it pretty much requires federal agencies to assess their federal actions and evaluate any potential environmental impacts that it may cause. So federal actions can include federal permits, licenses, funding, and actions taking place in federal land. So really the purpose of NEPA is for federal agencies to assess their actions in order to minimize, mitigate, and avoid impacts as much as possible from their projects. So what does this look like in practice once it's implemented? Each of the federal agencies has their own set of NEPA rules that they implement and abide by. And the levels of environmental review ranges. It starts from a categorical exclusion, which I'm sure you guys have heard, CEs, CADXs, and it kind of scales up from there. It goes to an environmental assessment, EAs, that culminates into a FONSI, a finding of no significant impact. And then from there, it can also scale up to an environmental impact statement, which culminates into a record of decision. So really, when it comes to telecommunications projects, the FCC license serves as that federal trigger. Therefore, we have to abide by the FCC NEPA rules. But when it comes to broadband deployment, which has been obviously very popular recently, the federal funding or the federal grant serves as that federal trigger as well. So then we have to kind of abide by the funding agency's NEPA rules, which it varies by agency by agency. So you guys are, for those in the room, I'm sure very familiar with the 10-point NEPA checklist that we have to abide by for FCC NEPA projects. But when it comes to NEPA review for grant recipients, specifically for broadband deployment, again, we have to follow the funding agency's rules for that. And one thing to keep in mind is that categorical exclusions, aside from the FCC, such as NTIA, which has been obviously very popular, USDA, those end up being a lot more robust in nature when it comes to the environmental reporting requirements and just the evaluation process as well. You're going to be seeing a lot of additional resources that are evaluated, such as environmental justice, socioeconomics, things that you don't typically see in an FCC NEPA checklist. And then, as Patrick with WIA mentioned this morning, there is a new federal land program comment out there right now that allows NTIA and other federal agencies to be able to use the FCC programmatic agreements for NHPA compliance if they choose to do so. And Aniela will talk a little bit more about that later. So in preparation for this panel, we actually had the opportunity to kind of pick NTIA's brain and some of their pain points that they've been seeing with broadband deployment projects that have crossed their desks. And they had 3 main key advice for grant recipients for the program moving forward. First and foremost is having a robust project description. They mentioned that that's a challenge that they've been seeing with pretty much every project that's crossed their desk so far. So really being able to, for the grant recipient to address who, when, what, where, and how is your project going to be implemented, you have to be able to address that question to ensure a smooth NEPA process from start to finish. The second piece of advice that they had for grant recipients is to be able to screen your projects early on for any constraints. And this is hot off the presses. Yesterday, NTIA launched a desktop tool. It's a web page that grant recipients can use to be able to screen their project footprints, to be able to see if there's federal, tribal, state lands involved, what kind of roads and railroads and other infrastructure are present within your footprint. Are there mapped wetlands, critical habitats, historic properties? Again, all of these resource items that if you screen early up front will be able to save you time and money down the road, and also avoid having to do additional environmental permits. And then the last piece of advice they had is that any project that crosses into federal and tribal lands may require additional environmental review for that landholding agency as well. And the most significant delays that they've been seeing so far has been those projects that go into, national forest lands and other federal lands in general. So their piece of advice is to avoid those if at all possible. Obviously, that's easier said than done, being here in the Southeast compared to if you go out west. But they have been seeing significant delays with project reviews, tacking on easily a year to your reviews as well. And I'll wrap it up by saying that NTIA is currently working on additional categorical exclusions that may be for use very, very soon, so stay tuned for that. So I'll pass it to Aniela for NHPA and Section 106 best practices.
Great, thank you very much. So switching to our traditional telecom, there has been no major change to the FCC's regulations in the past year. However, there were a few points of emphasis from the workshop in November that are worth going over. The first of these was that the FCC encourages applicants to hire Secretary of the Interior qualified individuals to identify historic properties. However, you are required to use those individuals in 3 cases. The first is to evaluate historic properties. The second is to complete the assessment of effects on historic properties. And the third is when you're conducting archaeological surveys. Secondly, they'd like to remind applicants that Google Street Views are not an acceptable substitute for recent photographs of the project area. However, you may use those in instances where it might be dangerous to get recent photos or if there are no historic properties present. Thirdly, identification of historic properties includes review of the National Register and SHPO-TIPO inventories. So tools like NEPA EDR check or NEPA map check are good for screening, but they're insufficient for identifying all the properties the FCC requires. This last point was not part of the workshop, but communications with the FCC has indicated that they no longer accept bundling of multiple small cells or multiple projects in one filing without the written consent of all potential stakeholders. So that would mean getting written consent from the SHPO, TIPOs, or interested tribes. And this is a shift from a previous attitude towards bundling, so just something to keep in mind. Finally, and most importantly, they reminded applicants to not start construction, and that includes vegetation clearing until your NEPA has been completed. If you move forward prior to NEPA, it's called a foreclosure. And most of the foreclosures I personally see involve projects that require more than the normal scope of work. So just going over a couple of scenarios when that occurs. The first is a conditional no adverse effect. So the FCC does permit SHPO or TIPOs to condition their findings with required actions to mitigate or remove an adverse effect, which would trigger an MOA. These conditions might include archaeological or tribal monitoring during construction, height reductions, stealthing, two of my favorite stealthings in the images, or installation requirements like certain setbacks, certain construction methods, certain mountings, or even prohibiting directional boring during construction. The directional boring, you can't see it if you have an archaeological monitor on site, so sometimes they might require open trenching. It's important to remember that these conditions are not optional and they must be required to be in compliance. And recently we've seen a trend in SHPOs and TIPOs requesting photographic evidence that these conditions were met after construction is complete. The next scenario is special studies. So the NPA does allow for SHPO or TIPOs to identify additional properties that they feel may be affected after the Form 620 or 621 has been submitted. And they also may request additional studies to assist with the assessment of effects. And those studies may include balloon or crane tests, photo sims, viewshed mapping, alternatives analysis, additional archaeological work, and determinations of eligibility for historic properties. Once these studies are completed, you'll resubmit them to the SHPO and TIPO, and that will restart the 30-day shot clock. It's good to remember that Section 106 is a conversation. Sometimes it's a really short chat, and sometimes it's a long dialogue with a lot of back and forth. And it's just important that construction does not start until that dialogue is complete and a consensus has been met. Finally, touching on broadband again, just in the last 2 weeks, the ACHP released an amendment to their program comment for communications facilities on federal lands. And what this comment did is it expanded the opportunity to use the original comment to any federal agency. Originally, it was a select few agencies. Now any agency can choose to use it. It also streamlined Section 106 for broadband on all public and private lands. It doesn't, however, supersede the FCC's NPA. So those rules are still in effect if your lead agency is the FCC. So your first step when you're considering Section 106 for any broadband projects is to identify the lead agency and then ask them if they're going to be using the program comment. I can tell you that the NTIA is the agency that requested the amendments, so they will be using the comment. And as we stated, they are working on more categorical exclusions. Under this comment, there may be no need to complete Section 106 if it meets a number of criteria, including being surveyed previously with negative results, if it's comprehensively disturbed, if a Secretary of the Interior qualified professional indicates it's a low sensitivity, or if it meets one of the exclusions, one of the new exclusions in this program comment, including specific exclusions for buried or aerial cable. So it's anticipated that very few projects are going to require full Section 106. However, you still will need to complete what they're calling a records check of the SHPO or TIPO or federal agency inventories to see if those conditions are met. And that's very similar to the record search you already complete for traditional telecoms projects. So your environmental vendors, including any of us on this panel, can help you with that records check and help you navigate through the new exclusions and hopefully the new categorical exclusions coming up. We'll pass it along.
Yeah, so I was going to just make a comment real quick if I could. So the themes are things that we do really well in the wireless industry and in the telecommunications industry, right? Robust engineering plans, make sure you've got good documentation to what you're doing before you go build, right? Measure twice, cut once. And then that leads into good best practices for construction, working with the federal and state level jurisdictional entities to make sure that what you're doing can be approved. And I think there may be some changes coming in the future. You know, we'll see and we'll work through those. But that's, you know, WU covered high-level NEPA, and Yella covered what to expect in a Section 106 consultation. And then that's going to extend into broadband from at least a administrative compliance process. It may lead into, you know, physical construction compliance requirements as well, but that's a case-by-case basis. And then Erica is going to touch back into what do you do in the tribal situation where you're on tribal lands and have tribal consultation going. So, you know.
Yeah, so we'll take it back to your regular FCC projects. If you guys attended the FCC workshop last year, you'll probably recognize a lot of these high points on the slide. But the FCC just reminded us that to initiate consultation with tribes, you need to be using their website. This will come back in a few slides. But the Tower Construction Notification System, also known as TCNS, is going to be utilized to initiate consultation. The FCC also reminded us, make sure we're contacting tribes in their preferred method, having sensitive and respectful communication, and providing reasonable opportunity for tribes to respond and following up as appropriate. I think it's good to note here that tribal consultation cannot be fast-tracked. There is a set timeline that the FCC has outlined, and in order to provide them appropriate amount to comment, we have to follow those timelines. So if you've been doing regulatory for a while, you've probably had at least one project where a tribe has requested something specific. These special requests are typically utilized to avoid adverse impacts to sites of religious and cultural significance to a tribe. These requests can include monitoring, which we'll talk a little bit more on the next slide. They can include review fees. A tribe may request to escalate the consultation directly with the FCC in a process called government-to-government consultation. And like Aniela kind of touched on during her Section 106 discussion, tribes can request additional testing. I think it's important to note that tribal historic properties are not always identified in SHPO or the National Register, which is why we always offer tribes the opportunity to comment on our projects. So, if a tribe does request a monitor, we can divide these into two different groups. A tribe may request a monitor that is a tribal monitor. This is someone who is specialized by the tribe with knowledge regarding a specific site, some type of religious or cultural background that only the tribe would have knowledge of. So when this type of monitor is requested, we will coordinate with the tribe to arrange for that tribal monitor to be on site during construction. This is typically during all ground disturbing activities. The other type of monitoring is when a tribe will defer to an archaeological monitor. During this situation, you can coordinate with an SOI qualified archaeologist to have a monitor on site, again, during ground disturbing activities, during construction. After construction is completed, the archaeologist will put together a report and will send it to the tribe to satisfy that request. Okay, and then larger view for fiber and broadband. Fiber and broadband work can be subject to approval through various state agencies. This may, regarding tribes, introduce the requirement of contacting state tribes. And typically with our FCC projects, we're not contacting state tribes. So if you have that happen, you can reach out to the reviewing agency to determine how best to get a list of tribes for the projects you're working on. The good news is, as was discussed, the program comment, NTIA is using the TCNS system, so a lot of our projects are going to look very similar to our typical FCC NEPAs. I did highlight here, if you've ever worked in California, they have a specific state, it's called the Native American Heritage Council that maintains a list of state tribes for California. Other agencies also have tribal lists that look a little bit different than TCNS. For example, HUD uses a list called TDAP.
All right. So I'll talk about a few regulatory updates related to waters of the United States, otherwise known as WOTUS, and provide a couple of threatened and endangered species updates as well. To give you an idea of the background some background on the complexity of the WOTUS issue, we've had 5 different definitions of WOTUS since 2015. There have been changes to WOTUS in every year since 2018, including multiple changes in some of those years. In fact, there's been some kind of change to WOTUS in approximately 25 of the last 52 years since WOTUS was born. Currently, states and different Corps of Engineers regulatory districts are following different versions of the WOTUS definition, and states and local jurisdictions may have their own rules and permitting requirements, some of which may be changing in response to the recent WOTUS changes. So the current WOTUS definition is known as the conforming rule, also known as SACIT. It's been effective since September of 2023. It was in response to a Supreme Court case, SACIT versus the EPA, and included some seemingly minor text changes to the prior rule, but when put into practice, those changes are fairly significant. The slide here shows a simplified version of the current definition, with the bold text being the primary changes to the previous rule, which had come out earlier in 2023. So 2023 was a busy year for WOTUS, but they've all been, it seems like, here lately. Numbers 1 through 4, typically not applicable to most wireless and broadband type projects, but numbers 5 and 6 could have significant effects. So number 5 reads, tributaries of the waters above, and this is simplified, tributaries of the water above that are relatively permanent, standing or continuously flowing bodies of water, which excludes from WOTUS what are called ephemeral streams, which are streams that flow only in direct response to precipitation, but had been regulated as WOTUS under previous rules. Number 6 states that WOTUS wetlands are those that are, quote, adjacent to the waters listed above, and the rule clarifies the definition of adjacent as having a continuous surface connection, which is still subject to a very large amount of interpretation. But ultimately, this change results in many wetlands that were considered WOTUS in the past not being considered WOTUS currently. All So what does this mean for everybody as the regulated community? Impacts to WOTUS have to be permitted at the federal level. That hasn't changed. But that could result in significant project delays, additional costs, more in-depth environmental reviews by FCC, NTIA, other agencies. However, under the conforming rule, wetlands and streams that were an issue in the past may no longer be an issue, including those ephemeral streams and wetlands that don't have the continuous surface connection. The agencies, the Corps of Engineers, the regulated community, the consultants, everybody involved are still feeling out these recent changes such that answers to questions about jurisdictional status and permitting requirements may not always be as clear up front as they maybe have been in the past. So expect that there could be delays in your projects, especially where verification of that jurisdictional status is needed by the Corps of Engineers. Also, expect your projects may be subject to permitting by multiple agencies in addition to federal. State and local may have their own rules regardless of whether wetlands and waters are considered WOTUS or not. And of course, those requirements can vary depending on your location. So what can be done to minimize the impacts of wetlands and waters issues on the success of your projects? Obviously, avoiding and minimizing them in the first place is a good practice, but desktop pre-screening can be helpful. We have a great article on our website. It's called How to Spot a Wetland from 100 Miles Away, and it details the use of things like soil maps and topo maps, National Wetlands Inventory, and aerial photos. And while it's certainly no replacement for boots on the ground by a qualified wetland consultant, it can be useful to identify those obvious features kind of in that site selection and early design phase of your project. Consider conducting site walks with your consultants or knowledgeable persons who can identify features in the field during that prelim design phase and avoid them early on in the process. Where impacts would occur, or where impacts perhaps are in question because you've got features that the jurisdictional status is in question or they're close by your site, consider measures such as reducing compound size, rerouting access utilities, directional boring of utilities, or overhead utilities. Also, asking the right questions early in the process can be beneficial just to overall project planning by understanding your federal, state, and local permitting implications, by identifying requirements such as stream and wetland buffers, which are usually administered at the state and local level, and there may be other permits and or reviews that are required specific to wetlands and waters at that local level and state level. So I encourage everybody to lean on your consultants. I know Aniela said it, but you know, our job is to understand these things, and we can certainly help you through these pretty complicated regulatory situations, whether it be wetlands and waters or anything else that we're talking about up here today. All right. So shifting gears from WOTUS to threatened and endangered species, just very quickly, bats continue to be a consideration for many projects in our region. So we've got the tricolored bat, which is a proposed endangered species and has been for about the past year and a half, remains proposed. The U.S. Fish and Wildlife has indicated that they are working on consultation guidance for the species, which we've not had for this species as of yet. We have no idea what it's going to say. But our understanding is that the species will be listed as endangered at some point later this year. If you were here last year, we were in the midst of some big changes regarding the northern long-eared bat, which had been reclassified from threatened to endangered, and we've been working under interim consultation guidance that's set to expire next week on April the 1st. However, Fish and Wildlife put out a memo a couple of weeks ago stating that they would be extending that interim period on into the summer while they work on guidelines for consultation beyond the interim period, which we didn't have as of yet, which is why they're extending the interim period, I guess. But our understanding is that the guidance that they're working on will apply to both the northern long-eared bat and the tricolored bat, which is really good news and should help to simplify and streamline consultation for those two particular species going forward. Thank you.
All right. So that is our regulatory panel. Does anybody have any questions? I don't see any hands going up. Just, another reminder, right? You don't have, the more you're aware of regulatory requirements, the more you'll know, the more you should gather information. Do rely on SY qualified individuals, historians, biologists to apply any exclusions or help you come up with a program to document a proper process if you don't already have one. And so, do you guys have anything else? That's it. All right. We'll hand it off. Thank you for your time.
Thank you.